We are requesting you to join me. I would love to have you for that. Your permission is needed. My permission. It's always there, sir. So we can start. Formally, I extend my good morning once again to you. Today, the second part of my presentation, which I titled as Legal Pluralist Society and Access to Justice as its indispensable pillar. Yesterday, I explored the whole concept of access to justice. And I said that access to justice is an important component of the rule of law, because rule of law, administration of justice according to law, it can't be upheld. The majesty of the rule of law cannot be upheld until or unless it is enforced. And access to justice is immediate. But in that exploration, we have reached the dead end. We said that while exposing Article 37 of the Constitution, I said this concept of access to justice fails to swear into the concept of duty, which is envisaged under Article 37. What was the basic snag? Yesterday I indicated. Basic snag was that the concept of duty under Article 37 was not incorporated in the Western jurisprudential thought, in which rights and duties are relative. It was introduced by following the classical tradition of Indian law, and that is the whole concept of dharma. Dharma is the concept of duties, duties of diverse natures, duties of the king, duties of the subjects, religious duty, social duty, all kinds of duties are there. Not that they were unaware of the concept of rights. No, they were very well. But then, by realizing the limitation of the rights and duty correlated concept, that my right is your duty, so it would mean that my right would remain incoherent, incomplete, imperfect, until or unless you perform your duty. So my right is totally dependent upon you. So can there be a mechanism in which the whole concept of right can be made independent of duty that way? So to that extent, they said, come back to the duty is the more fundamental, because fulfillment of my right depends upon the fulfillment of the duty. So the focus of attention has to be duty rather than right. And if this concept is followed, I think the society would move towards idealism, because that is the only way. And in our day-to-day life, we are experiencing that duty is the first and foremost fundamental. If it is not, no, this concept of duty as I said, in the Indian classical tradition and also under the Roman law, Pater Potestas, the power of the father over the children and the family. And this was, as I said yesterday, this very important message which you had. This was the basic fundamental of organizing the Roman society. And Rome was not built in, you know what kind of an excellence they had produced. Now, corresponding to that, Indian classical tradition also followed the same thing. Karta of the joint family. His power was extreme. So it was this concept. What happened? The concept of access to justice was completely subsumed by the duties of Karta. See, Karta was not required to be prodded from outside to ye karo. No, Karta was Siva. So similarly, I consider state is an equivalent of Karta. State, and this is what Article 45. State, which is it is state shall endeavor to provide free and compulsory education to all children. So here the concept of a state was analogous to the concept of. Now I come to the second part, which is slightly more tricky, but let me see how do I negotiate. Legal pluralist society. I raise a question, what is the generic notion of pluralist society and its legal connotation? Because it is a legal pluralist society. The title is Legal Pluralist Society. So I was tied down that I had to pay my attention to the word legal, which was very consciously introduced in the conjoint concept of legal pluralist society. The generic notion is pluralist society in the context of modern civil society is not just an hodgepodge or a haphazard collection or conglomeration of people, but an organized, inclusive social order, which is constituted of people of different complexions, belonging to different religions, races, castes, sexes, ethnic groups, or cultural tradition. No, this is as a generic notion, this is how I. But then I have to deal with legal pluralist society, meaning thereby that it refers to the pluralist social order which is envisioned under the Constitution. Constitutional notion of legal pluralist society, what is that notion? To my mind, it may broadly be located in the fundamental right to equality and non-discrimination under Article 15, read with Article 14 of the Constitution, which stipulates that in our Indian polity, all citizens are free to organize themselves freely, and the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth. This is how I trace to the genesis of pluralist social order in a constitutional framework. Now, what is the core constitutional value of such a legal pluralist society, which makes it enduring and prime basis of peace and sustainable development? And this is the important question I have raised, that we need a pluralist society which would raise to the level of such an extent that it enable us to live in peace and make development which is sustainable, not transient, not by forcing people to do this military regime kind of a thing. No, we are not envisaging that. So now question is, after having said that they located its core value somewhere in Article 15 read with Article 14, but what is that core value which makes it sustainable, enduring, ever afterwards? What is that? This is reflected in the preamble of the Constitution, which unequivocally comments that fraternity to be read as legal pluralist society, fraternity to be read as legal pluralist society, nurtured by justice, liberty, and equality, needs to be reinforced by the distinctive value that assure what their distinctive value? The dignity of the individual and the unity and integrity of the nation. Dignity of the individual and unity and integrity of the nation. This is how I look at it. Now, critical question I raise here. Now, how do we realize such a comprehensive notion of legal pluralist society, which is constitutionally christened as fraternity, with all its distinctive attributes of justice, liberty, equality, assuring the dignity of the individual and unity and integrity of the nation? It's a very complex. How to achieve this? This is the most challenging question. How to achieve this? How to achieve this? I pondered over this. And then, in my submission, it is here that access to justice through the contrivance of courts becomes an indispensable ally in the realization of the legal pluralist society. This is an important observation you have to keep in mind. You can question it, you raise any number of doubts which come to your mind, I'll be happy. Because it is I who am claiming it. You see that in my submission, it is here the access to justice through the contrivance of courts becomes an indispensable ally in the realization of legal pluralist society. So therefore, I myself raise the question, how to go about it, you see. How to go about it. Now, this is the question. Realization of legal pluralist society through access to justice, that is through the intervention of courts of justice, is indeed a very complex constitutional phenomenon. It's a very complex constitutional phenomenon requiring continual attempts to adjust and reconcile the competing, conflicting interests on the touchstone of fundamental rights and their foundational values. I call it as basic structure doctrine, enshrined in Part 3 of the Constitution. Now, this single paragraph involves a lot of explanation, which I'm not, the time constraint would not permit me to go, but at the same time, the statement on the touchstone of fundamental rights and the foundational values underlying those rights, which is called the basic structure principle. Recently, just 2 weeks back, I did deliver a 2-hour lecture at the ILI, running a certificate course. So they asked me to give my presentation. The duration was of an hour and a half. It went on for 2.5 hours. There was so much interest was involved, so much interest was there. I was really, really very happy. And one of the proposals came, he said, we would like to authenticate. He said, take up the project if you so like. You see. So this was a very rewarding exercise for me. But here in this case, I said it is a very complex constitutional phenomenon. How to go about it, how to elucidate such a complex constitutional phenomenon involving continual conflict of competing interests in the realization of pluralistic social order as envisaged by the founding fathers of our Constitution through access to justice. Now, this is the challenge for me, and how to elucidate. Elucidation of this complex constitutional phenomenon, this I will do through the instance of a recent critique of mine of a Constitution bench judgment of the Supreme Court in the case popularly known as Sabriwala temple case. Have you heard the name of Sabriwala temple case? See, which evoked a kind of a social upheaval, if you recall. This critique of Sabriwala temple, I presented this critique as the 57th Punjab University Colloquium Special Lecture on August 27, 2019, under the title Socio-Religious Reform through Judicial Intervention, its limit and limitation under the Constitution, And this critique of mine was published in the form of a monograph by the Punjab University with a foreword by Justice Ashok Banu, former judge of the Supreme Court of India, and published by the Publication Bureau, first edition 2020. So the date of my lecture is important, and that is the 27th of August 2019. I may also mention that this was the 57th lecture. University has introduced a series of session lectures in which they would invite a physicist, a chemist, a performing artist, or a musician. Each one of them will come with a different flavor. But breaking was done in my case, that it is for the first time they said that they would like to publish it. So 57th is the first publication. It is available. I'm sure that university can get any number of copies there. Not very heavy price. But this is one of the most revered deity in South, most revered deity in South. So I did not know. I would like to know about this deity. This is the first question. And what is the distinctive character? Because it evokes a lot of controversy. Supreme Court judgment, just it's spread like a wildfire throughout India. So I would like to know what is the distinctive character of this deity, which has caused a havoc in social order. And why they have the Supreme Court judgment on Sabriwala temple entry issue caused a sort of social upheaval across India. And finally, why and how should I undertake this critiquing exercise? This would be important. Now, first, this is the view of Sabriwala temple. It is a 12th century old temple, 12th century old. And it is, in fact, the deity inside in it is that of a Lord Ayappa. The story goes that Lord Ayappa was one of the avatars of Vishnu going so slowly, which means that it was most revered. Why it is came to be known as Sabrimala? Because it was located as a place in one of the districts of this state of Kerala, known as Sabrimala on a hilltop. So therefore, it is came to be known as a Sabrimala temple. Now, the pilgrimage season is from November, beginning of November to the end of January. Now, this is important date which you must bear in mind. Otherwise, we will not understand what is happening all of a sudden. And pilgrimage number is given from 15 million to 50 million per year. It is visited so much, you see. Now, second question is what the distinctive character of Sabrimala temple? Now, this is an important concept which you have to understand. The deity of Lord Ayappa installed in this temple bears a very special character. What is that? The eternal celibate character, Nashrik Brahmachari, Ajivan Brahmachari, and customarily, owing to the deep reverence for the celibate nature of this deity, women devotees of menstruating age, 10 to 15 years of age, are prohibited to enter this temple and worship here. First, you have to understand that this is an ancient temple and this is a custom that women of menstruating age, they are prohibited to enter. So women as such, they are not denied entry. Above 50 years of age, below 10 years of age. Or the qualification is only that they are in a non-menstruating period. So it is this is custom. Now this custom was codified by the state of Kerala in a rule which is known as Rule 3B. ये थोड़ा सा याद रखेंगे आप कि Rule 3B ये है क्या? It is nothing but it framed in the exercise of power. They passed an act of 1965. Under that act, rules were framed. Under that rule, there was one rule. Now, this rule codifies the customary practice. Now, what is codification? Quickly, just only quick reference. I said custom was codified. Now, what is codification? When you say recognition, which would mean that custom was not earlier recognized?
Why the state?
Yes, why the state? Yes, I'm saying.
Statute form.
You see, to that, I think there is a lot of controversy in India during the British colonial rule, of which I think you heard a lot in the opening session. You did mention about the colonial. The colonial ruler, before their advent, 1600, British India Company, I'm not going to that part of it. There was only one rule in India. You know what was that? It was only custom. Custom was the law, only law. And Britishers came, they recognized this. So what they did, they said, we are unaware of the custom, so but we have to rule over you. What did they do? First exercise? Converting the custom into right. Not recognizing. Recognition was already there. Custom is only recognize this fact that custom is operating and it converts the lives of the people. We have to simply enforce it. So therefore, this codification, I think the difference between codified law and customary law is a custom always remains in the oral tradition of society. It's passed on from father to son, orally. And codification is converting that unwritten into written and put it into some kind of a systematic form. This is what is codification. So codification does not violate anything or add anything to the customary rule. This is basic to a sensitive, because only then we would be able to understand the rest of the analysis. That this has to be understood that custom governed the life of the people, and state, in order to facilitate, they made it into a black and white. There's one difference only. Once it is put into black and white, and this is the grievous injury caused the Britishers to the Indian scenario. The moment it put into writing, custom ceased to grow. If it was an oral word from Mars, father to son, it kept on changing. If I use the language of literature, I think it always remains in a melting pot and taking the shape according to the, this is the competition. So now the state of Kerala very faithfully reproduce that customary practice into codified form. Now, this constitutional validity of this first question is before Supreme Court through a public interest litigation. Petitioners are important, Indian Young Lawyers Association and others. In fact, this was moved by young ladies from Bombay. And they said that, what is this rule? Can't we go and visit? This is discriminatory. So they challenged before the Supreme Court of 5 judges bench. Very important bench. It led by Chief Justice of India and consisted of Khanwalkar and Nariman Chandrachud and Indru Malhotra. Indru Malhotra was the only
Presenting
judge. The critical contentious constitutional issue to be resolved was whether this Rule 3B, barring women of menstruating age from entering the Sabriwala temple, is constitutionally consistent. This was the question to be resolved. How did they resolve? The 5-judge bench of the Supreme Court Sabriwala temple, by a majority of 4:1, has held that Rule 3B, excluding the menstruating women for Sabriwala temple, is unconstitutional, as it violates the fundamental rights contained in Article 14, 15, 25, and 26 of the Constitution. In which Chief Justice wrote a judgment for himself and Justice Khanwalkar. Chandrachud wrote for himself and Nariman. Indru Malhotra wrote her dissenting. Now, when this scenario came, that Indru Malhotra said that women of menstruating age, their prohibition to enter is perfectly constitutional, and other 4 judges said that no, it is unconstitutional. So at the first blush, I also started thinking, this is Indru Malhotra. It is she who is saying. So that's fine. And it was an unprecedented decision. I quote a statement. 68 years after the advent of the Constitution, we have held that in providing equality in the matters of faith and worship, the Constitution does not allow the exclusion of women. Para 294. 68 years after the advent. Now, how do you see this interpretation? See, constitutional provision remain the same. Article 14, 15, 24, 25 remain the same. Till 68, because the judgment was given in 2018. So therefore, he is referring to the 68 years. Which means that until 68 years, this rule was perfectly constitutional. This rule was perfectly constitutional. And it is only after this interpretation that this is no, the Constitution. And what is Constitution? Constitution is what the Supreme Court says it is. Because Article 141 says, the law declared by the Supreme Court shall be binding on all courts in India within the statute. It is the Constitution speaks through the Supreme Court. This is provided in the Constitution. So therefore, now the complexion of Constitution after the judgments, after 68 years, has all of a sudden went into a transformation. Unprecedented decision of the majority court has evoked two opposite reactive responses. Unprecedented, which I have described as, for the sake of my convenience, one opinion modernist, and another is that of traditionalists. This is just only a way of distinguishing the two. Modernist response, rationalist or positivist, from jurisprudential angle, those who are followers of the Austinian concept of law, they would call it positivist. You see, they make law. Law is made. Law is a command of a sovereign. It is evident in the writings of the opinion makers, such as writers, editors, who wholeheartedly hailed the judgment of the majority court and vehemently resisted the reversal by the state. They said, let me cite the editorial in Hindustan Times. Do not outlaw social reforms. Going against the progressive court judgment is a step in the right direction. Wrong direction. It would be in a wrong direction. Inadvertently, I spoke the right thing. Yes. The opposite view was of traditional response. It is evident in the precipitated protests by the various Hindu organizations led by both men and women. Right from the day when the judgment was delivered, September 28, 2018, there was processions, protests, silent protests. Save Sabrimala. Stop interfering in the affairs of Hindu temples. I really, when I saw this, I said it was a kind of a protest pre-planned. All of a sudden, judgment is delivered, and right on that day, the posters already there. One may be that media is so strong and technology is so strong that you can invent just in a moment, you see. But I think there was another reason. Another reason was that the proceedings of the court were published by all the newspapers and in detail as much as possible. As much as possible. So therefore, the proceedings which were going on before the court, it was giving an idea that they are going to play this large 30. They are going to uphold, they are not going to uphold Rule 3B, which prohibits it. So therefore, they were as if ready, determined. Now, this is the picture of December 24th. I told you the pilgrimage season is from November, beginning of November to the end of January. So 24th happened, event happened on 23. It takes reported one day later. What happened was that 11 young women, as if holding the Supreme Court decree in their own hand, they reached the state of Kerala. They approached the state of Kerala. He said, this is our constitutional right to enter the Sabrimala temple, and it is your responsibility. It is your responsibility to see that nothing happens in this. So, state made a police bandobast for them. And when they started marching towards it, they found that there was a sea of humanity because it was a pilgrimage season. Lakhs of devotees were there. They just simply shoot them away. They just ran away by looking at it. Then another picture I depicted is of January 4th, which has happened on January 3. January 3, what happened is two young women in disguise, probably they pretended as if they are old women, you see, and in disguise, they reached the Sabrimala temple. And once they reached there, They disclose their identity. Hey, here we are. In our right. Here we are. No, this instantly silent protests were converted into violent. This was a very peak situation in the whole of the country. Immediate, now, immediately after the delivery of the judgment, there were review petitions were filed. There were as many as 68 review petitions were filed. As many as. Now, Chief Justice, taking cognizance of it, realizing that review petitions have to be disposed of, and it need to be disposed of quickly. So he said that all right, he would need to make unprecedented decision. He said he would hear immediately. He would dispose of the review petition immediately. So they subsided. And he also said, usually the review petitions are disposed in the chamber of the judges. No open hearing, no new evidence to be adduced. Chief Justice said that realizing this is a realistic law appraisal, Constitution is made for us. He said, we would hear your case in the open court. We would allow you to be represented by your legal representative lawyers. We would also allow you to adduce any new evidence if you so like. So people felt immediately there is a calm quiet. But then he said, but sorry that I can't do it immediately because I'm handicapped, because one of the, and this petition is to be review petition to be heard by the same bench, and Justice Indu Malhotra is on a long leave, sick leave, and she would return only at the end of January or the beginning of February. But you trust me, he said, I will do it. So they subsided, and then he immediately, as is promised, and the situation was put into control. Now, this was the scenario when, as a social scientist, I thought that so much has happened. I must think whether I should do the critiquing or not, you see. So this is the second question. I said, why critiquing of Sabdivara temple is considered designated? Why is considered essential? I said there are two principal reasons for me to undertaking this critiquing exercise. First principle of critiquing exercise, since the unprecedented decision of the Supreme Court impinges upon the fundamental right to freedom of conscience for the first time, 68 years after India, for the first time, a value which is intensely private and personal in human life existence, it has created a sort of social upheaval which could never ever be the result of pursuing freedom of conscience. This has prompted me to re-look at the judgment critically. The first thing, if it's unprecedented, I must look into it. This is the first reason. Second reason was that it is a matter of serious academic concern to explore how come the five-judge bench of the Supreme Court is divided in interpreting the same provision of the constitutional fundamental right to freedom of religion, and that too in relation to the same fact matrix presented before them. Critiquing is imperative to resolve the duality of interpretation, as duality is destructive of the constitutional system of governance. You see, I was annoyed because Justice Malhotra, women, why has he gone against it? I said, even in this single voice, I was reminded of Copernicus, you see, 16th century. It is single voice who said that, no, it is the earth which revolves around the sun, not vice versa. The person was persecuted. But ultimately, his single voice won against the rest of the world, you see. Who knows, Indu Malhotra might have that kind of a futuristic concept of constitution. Question was that, how do I do it? How do I the critiquing exercise? We wish to critically examine the decision of the Supreme Court by construing the fundamental right to freedom of religion as enunciated in Article 25 and 26, along with Article 14 and 15 of the Constitution, de novo, on the first principle of constitutionalism, that commands us to uphold the sovereignty of the Constitution. You see, when I was doing this critique, I was sharing with my young teachers, you see. And all the time the young teacher would say, Doctor, the stand which you are taking, you will be hauled up for court of contempt, you see. Because you are, I said, and this is important for you, an important lesson. I said, there is a difference between a critique and a criticism. The difference is a critique is a criticism with reason. A critique is a criticism with reason. And if you reduce the reason, who would take the hold up until they are able to point out that your reasoning is faulty? If reasoning is faulty, all right, it could be an error of judgment, as your judgment are reversed day in, day out. So therefore, there is nothing. Error of judgment is absolutely understood. Now, these are the four fundamental rights. It's a question of sheer interpretation. How the Supreme Court majority judgments are interpreted, and how do I perceive my own interpretation. And on that basis, I tend to say that judgment of the Supreme Court needs reconsideration. Now, this was my stand. Now, the question is how to do it. That is the most important part. And that's the important part of the critique. I raised three critical questions. And these are central to my critiquing. Three basic questions. First question I said, questions are very important to understand. What is the juxtaposition, relative position, of the fundamental right to freedom of conscience as spelled out in Article 25 in the complex of fundamental rights as enunciated in Part 3 of the Constitution? Do you understand the juxtaposition? What do you mean? Juxtaposition? The relative positions. Juxtaposition is the relative position. You see, relativism in relation to this right vis-a-vis this right. How do you do the placing? What is more important, less important? You know, this is the juxtaposition. Now, how this question has come to my mind? This question has emanated from the bare reading of the provision of Section 25, Clause 1. It opens, subject to public order, morality, health, and other provisions of this part. All persons are equally entitled to the freedom of conscience and the right freely to profess, practice, and propagate religion. Now, this is the clause. Now, I would say, how has the majority court interpreted the subject to clause? What is the literal meaning of this? That the freedom of conscience and the right to profess, practice, and propagate religion is subject to other provisions of this part. Subject to other provisions of this part. So, which means freedom of conscience have got some limitation. And what is that limitation? That limitation is provided in the subject to clause. Right? Now, how the Supreme Court majority judgment has interpreted. I'm quoting now. In protecting religious freedom, the framers subjected the right to religious freedom to the overriding constitutional postulates of equality, liberty, and personal freedom in Part 3 of the Constitution. I've highlighted the word overriding. Bear in mind. Then there's another statement I quote from the judgment of the Supreme Court, para 175. In the constitutional order of priorities, the right of religious freedom is to be exercised in a manner consonant with the vision underlying the provision of Part 3. The equal participation of women in worship inheres the constitutional vision of a just social order. When I say emphasis, my emphasis is on constitutional order of priorities. Now, what do these two statements reveal about the emerging perspectives of the majority court for their holding by using these words, overriding and constitutional order of practice? Emerging perspective is what they want to convey. They want to convey is fair reading, I have tried to read as fairly as possible. In the constitutional order of priorities, the fundamental right to equality and non-discrimination under Article 14 and 15 overrides the fundamental right to freedom of conscience under Article 25. This is what they want to say. This is what they have communicated. Now, I posed a question, pointed question. Poser is, read this poser carefully. That in the scheme of Part 3 of the Constitution, my poser is there any hierarchy among the fundamental rights which prompts us to infer and say that fundamental right to equality and non-discrimination under Article 14 and 15 override the fundamental right to freedom of conscience under Article 25 clause 1? Is there any hierarchy? Is there any hierarchy? I looked for, and what was my answer? We find none. None whatsoever. I'm saying it in the assertion. There is no hierarchy among the fundamentals. In this assertion of ours, we are amply supported by the concluding statement in the dissenting judgment of Justice Indu Malhotra. Concluding statement, because in the analysis, I did not find anything of that which I wanted to convey. But in the conclusion, she said, what she said? She said, the equality doctrine enshrined under Article 14 does not override the fundamental right guaranteed under Article 25 to every individual to freely profess, practice, and propagate their faith in accordance with the tenets of their religion. Just the opposite. Are you seeing it? Please bear in mind. My inquisitive question, what then is the basic flaw in the construction of subject to clause of Article 25 by the majority court on the basis of principle of hierarchy, such as priorities and overriding in the scheme of fundamental right? कि ये जो hierarchy पढ़ी उन्होंने, it override, इससे क्या नुकसान हो गया है? क्या? What is the limitation hierarchy से? Indu Malhotra ने कहा, it does not override. She had not said, elaborated anything, neither in the judgment. This is the part of the conclusion, which is important. तो इससे नुकसान क्या हुआ? Because I must make a thorough inquiry. I have deciphered a flaw in the. What is that? The majority court construction of the subject to clause of Article 25(1) on the basis of hierarchy, it tends to obliterate the independent identity and autonomy of the fundamental right to freedom of conscience, which is guaranteed so openly and eloquently under the substantive provision of the same article of the all persons are equally entitled to the freedom of conscience, but subject to. But subject to. So if you say subject to is override karte, so what is the limitation? When freedom of conscience is becomes subservient, you see. There is no hierarchy. On what basis do you say subservient? Then the question is limitation and how to overcome this. उन्होंने सब्जेक्ट टू क्लॉज ऐसे पढ़ा है, तो उस सब्जेक्ट टू क्लॉज को कैसे पढ़ना चाहिए, ये भी तो मुझे बता दें ना. How to overcome this basic flaw in the construction of the subject to clause of Article 25 consistently with the right to equality and non-discrimination under Article 45. Now, my own reading is understanding of the whole principle of equality is that our prescription, my prescription of understanding that this is how subject to clause need to be interpreted. In our view, in my view, the basic flaw can be remedied by recognizing that the subject to clause of Article 25 inheres two opposite proximate perspectives, what I may call positive and negative perspective, as if they are the two opposite sides of the same coin. But the positive perspective, the subject to clause of Article 25, the positive perspective, it permits that a person in the exercise of his fundamental right to equality, non-discrimination under Article 14 and 15 has the equal right to have the freedom of conscience in the like manner as pursued by others under Article 25 of the Constitution, that is, by conforming to their religious tenets of religious belief and worship. I manufacture a simple example to illustrate the positive aspect. I'm a traditional Hindu. I wish to go and visit a Gurdwara and pay my respect to the Granth Sahib. Am I prohibited to go? Am I prohibited to go? The answer is no. This is the positive. The only limitation is that I would go, I would wash my feet, I would wear my hair, and do that. There's nothing to prevent. This is the positive person. This is the negative person. That the subjective clause of Article 25 does not permit that a person in the exercise of his fundamental right to equality and non-discrimination under Article 14 and 15 has the right to deprive others of their right to freedom of conscience under Article 25 by violating their religious tenets of belief, faith, and worship. Take the same example of my visiting Gurdwara. Now, I'm allowed to go if I wash my feet, scale my head. But can I say that no, I will go there, it's my fundamental right to equality, but I will go suited, booted. I will I will not cover my head. Or if I'm a Christian, he said, I go to the church, suited, booted, I would go to the Gurdwara in the same way. And would I be permitted to? This is the negative aspect of subjective clause. Now, about objective of conjoint consideration of positive and negative perspective of subjective clauses. Now, this is that it enables us to preserve the independent identity and autonomy of the freedom of conscience consistently with the exercise of fundamental right to equality and non-discrimination. And this is the promoter, and this interpretation is promoting of pluralist social order. This interpretation is promotive of the pluralist social order. And it is this perspective which is missing in the majority judgment. Permitting the young woman of menstruating age petitioner in the exercise of their right to equality and non-discrimination under Article 14 and 15 of the Constitution to enter the Sabhivara temple amounts to depriving the devotees of Sabhivara temple respondents of their fundamental right to freedom of conscience under Article 25, clause 1 of the Constitution. In short, permitting the petitioner to enter the Sabhivara temple is potentially destructive of the respondent's right of freedom of conscience and thereby destroying the very basis of the pluralist society. The very basis of the pluralist society. Now, this was my first question and my response. Now, this is my second critical question. Second critical question is, what is the intrinsic value of the fundamental right to freedom to manage religious affairs under Article 26 of the Constitution? Understand the question. What the intrinsic value of what? Fundamental right to freedom to manage religious affairs. What does this Article 26 says? Now, this question of mine has emanated from the provision of Article 26 itself. Read it, Article 26. Article 26 says, subject to public order, morality, and health, every religious denomination or any section thereof shall have the right to manage its own affairs in matters of religion. Now, how has the majority court interpreted this provision? Majority court, I'm quoting it. Even, I have highlighted the word even. It's a mischief is contained in this. Even the right of religious denomination to manage its own affairs in matters of religion cannot be exercised in isolation from Part 3 of the Constitution. It being located in Part 3 of the Constitution, the exercise of denominational rights cannot override, again the same catch, cannot override and render meaningless constitutional protection which are informed by the overarching values of liberty in liberal constitution. What does it imply? Simple translation, that even the right to manage their own affair can be overridden by the other provisions of the Constitution. This is what it means. Our critical poser. Do the express provision of Article 26, like those of Article 25, make the exercise of denominational rights subject to other fundamental rights in Part 3 of the Constitution? My answer is certainly not. Yes. A bare comparative perusal of the provision of two Articles 25 and 26 reveals that clause, the other provisions of this part, presented is subject to clause of Article 25, is conspicuous by its absence in Article 26, which is apparently present but conspicuous by its absence. What does this comparative conspicuous absence mean with respect to the exercise of denominational rights under Article 26 of the Constitution? Is it without any purpose, meaning, or significance? I'm asking this question. Is it without any? Why the founding fathers have incorporated one place and eliminated at others? Critical, in my view, there is a critical functional significance of the word absence. Read this carefully. By freeing the exercise of denominational rights from the control of other fundamental rights in Part 3 of the Constitution, the founding fathers of our Constitution intended to accord the freedom of religion a much larger and bigger space in the matter of managing religious affairs by confining the control mechanism only on three specific counts, namely public order, morality, and health. If there is any count, for example, Supreme Court judgment said in the celebration of Diwali, is it if it's part of your religious rituals, but then you have to confine only up to this period or limited period or in a particular way or this particular intensity. And this was on ground of health use. So you could see that there is a kind of a provision, but not on any other count. So intriguing question therefore is, why has the majority court read the absence of control clause, namely the other provision in Article 26 as its presence? Now this was a very question for me. कुछ ना कुछ तो होगा ना उनके दिमाग में. I got read the judgment. In our surmise, I'm making a informed guess sort of a thing. The majority court judgment is imbued with the spirit of religious reform on the basis of rationality, and it is this spirit that has led them to examine the whole gamut of the right to freedom of religion on the grounds of equality and non-discrimination with little realization. The word little, with little realization. It's a very sensitive word used in English language. Little realization means the difference between little, a little, the little. Self-taught English has made me to learn this final distinction. Little, if it does not carry a or the, which means nothing. It's a polite way of saying nothing. With little realization of the functional value of the freedom to manage religious affairs under Article 26 in its own setting, which is independent of other fundamental rights in Part 3 of the Constitution. The spirit of social religious reform is reflected in the very opening paragraph of the leading judgment of the Chief Justice. He said, I'm quoting, historically, women have been treated with inequality, and that is why many have fought their rights. Susan B. Anthony, known for her feminist activity, succinctly puts it, men their rights and nothing more, women their rights nothing less, which means that there has to be absolute equality between men and women. Now, I'm quoting it that this is the statement made in the opening paragraph, which means the opening paragraph reveals the mind of a judge. How is he going to answer this question? How is he going to answer this question? Now, this manifestation of the spirit of religious reform is resolutely read and reflected in the interpretation of religious denomination, which is used in 26, Article 26. Majority court interpretation of religious denomination on the fact matrix of Sabharwala temple cases, the devotees have been deprived of the right to manage their own religious affair according to their own belief, faith, majority judgment, because in their studied view, they themselves do not constitute a religious denomination. They have gone so far, the devotees of Sabharwala temple, they are not even a religious denomination or any section thereof. Inasmuch as they do not have any common faith, common organization, and a distinctive name. I had no difficulty in dispelling this argument by quoting the minority judgment of Indru Malhotra. She said in her dissenting judgment on the same fact matrix clearly and unambiguously holds that the worshipper of Sabharwala temple called Ayappans. They were called Ayappans, you see, and that is bearing a distinctive name, satisfy the requirement of being a religious denomination or a sect, therefore, and therefore they are entitled to the protection of Article 26. Now, what is that protection, which is specifically provided under Article 26 through the introduction of the concept of religious denomination of any section thereof? This takes me to the last, third critical question. That what is the pivotal provision under the Constitution to protect the freedom of religion in the wake of socio-religious reform? Now, this is the question which I'm saying, that what is that thing? If a Constitution tells us where the social reform has to be done, in what way it has to be done, this is to be taken into consideration. This pivotal provision is contained in Article 25, 2 clause, subclause 5b, read with Article 26 of the Constitution. What does it say? Article 25, 2b specifically permits the state to make any law providing for social welfare and reform or throwing open Hindu religious institution of public character to all classes and sections of Hindus. And Article 26 protects every religious denomination. It protects every religious denomination or any section thereof from state interference in the matter of managing its own religious affairs. 26, subject to other provision of the party is conspicuous by its absence. In pursuance of Article 25 to be read with Article 26, reforms were initiated by the state of Kerala. They passed the Act of 1965. Under the Act, they passed the rules. Under that rules, they made rules. So Rule 3B is in perfect consonance with the constitutional provision of Rule 3B was enacted in pursuance of this, which I have also mentioned. Majority court decision said that this Rule 3B is ultra vires. Minority court said that it is not ultra vires, very clearly. And this led me to my conclusion of my critique. I have done the 5 submission statement in which I brought out the follies, in my view, lapses of the Supreme Court and how those lapses have been corrected. In the light of my analysis, these are merely submitted in brief. First submission, re-juxtaposition. This was the question which I raised. Majority court interpretation of subject to clause of Article 25 on the grounds of overriding right to equality and non-discrimination, it tends to obliterate the independent identity and autonomy of the right to freedom of conscience, which is not warranted by the scheme of fundamental rights in Part 3 of the Constitution. In our view, the subject to clause of Article 25, Clause 1 requires rereading. It requires rereading consistently with the independence and autonomy of the right to freedom of religion as fundamental right in Part 3 of the Constitution, admit no hierarchical basis among themselves. So it has to be read. Second submission. It is about the intrinsic value. Majority court interpretation of the fundamental right to freedom to manage religious affairs under Article 26, it tends to destroy the intrinsic value by unduly denying the devotees of Sabrimala temple of their freedom to consider themselves as a religious denomination, and thereby spelling out the normative structure of do's and don'ts as an expression of one's own belief, faith, and faith. If you say that devotees of Sabrimala, they do not constitute a religious denomination, what does it mean? Whereas they do constitute a religious denomination, that doesn't require any technical interpretation. And Hindu Malhotra has said very categorically, and nobody would have any dispute on that count. And once you deny that they are not a religious denomination, indirectly what it amount to, then you cannot lay down your do's and don'ts. What to do? The denial of denomination, that the denial of denominational nature is simply because, now this is a very charge I am raising, because the Sabrimala temple is visited by a person of different religious persuasion without ceasing their own faith or belief, which is totally negation of the philosophy of secularism and the conception of pluralistic society. See, their argument is, which is, I don't know how this argument has been raised, that the devotees of Sabrimala, they are not entitled to be called as a denomination, religious denomination, because Sabrimala temple is visited by people without changing their own religion, So which would mean that any person without changing their own religion means that they do not carry any specific religion by themselves. This is the argument reason, which in fact, if I visit to a Gurdwara, which I said, that if I'm denied, which would mean I can enter only if I relinquish my Hinduism, then and then only. Would that be pluralism? It is destructive of pluralism. And the third submission. Third submission is the majority court, in the wake of social religious reform, unwittingly removed the constitutional protection provided to freedom to manage religious affairs under Article 26 by reading the express absence control mechanism as its implied presence. Fourth submission, in a democratic setup, kindly read with me, in a democratic secular polity, which is essentially multiplex and not monolithic, we need to learn to respect and accept the religious persuasion of diverse people without unduly questioning their mode of their faith and worship, except to the limited extent on the constitutionally specified grounds of public order, morality, and health, wherein morality is to be construed from the point of view of the devotees of the religious denomination concerned. And in my view, this has been religiously rightly read by the state of Kerala in 1965 in formulating the Rule 3B. Fifth submission, the mode and manner of socio-religious reform. Read with me, again, I framed this para very carefully. Our salvation in a democratic secular polity lies not in forcing unity in uniformity from without, but in promoting unity in diversity from within. Diversity is neither discriminatory, nor destructive, nor even divisive. It is the essence of pluralism. It is the essence of pluralism, as it leaves the people free to evolve and unfold themselves and their own potentials in response to the call of space and time, Desh and Cup. In our exposition of Article 25 and 26, read with Article 14 and 15, is the catchword. Freedom of religion within the complex of the Constitution should not be mistaken for freedom from religion. Now, this was the critique which I presented in the 57th special lecture on 27th of August 2019. Now, thereafter, what happened? Unprecedented, three ensuing development in quick succession after the presentation of my critique on August 27. The first development was, which took place on November 14, 2019. Read very carefully, interesting. You see, my critique was in publication at that time. On November 14, it was still in the print. I immediately requested the university to stop press if I can add a postscript to what I have presented. So this enabled me to add a postscript. It will be a part of it. Now, what was this event on November 14? Pronouncement of the review judgment on November 14, 2019, reserved on February 6, 2019. Review petition result was reserved. In fact, when I was undertaking critique, I tried to find out from the Supreme Court, इसका review petition है, उसका क्या हुआ? I did not get any clue. I kept on inquiring for 6 months practically. I was writing, but I said I would take care. But I was sure that review petition is not going to anything, you see, because it was so powerfully done that way. So there was no 6th of February, it took almost 9 months. Full gestation period, you see, 9 months to deliver the judgment. Now, what are the judgment? This is the 5-judge constitution bench, referring the matter to the 7-judge constitution bench on 7 issues without deciding the review petition by a majority of 3:2. This is surprising. I said this was completely an unexpected, unprecedented judicial decision that instantly transformed, as if by a quirk of judicial fear, the initial minority judgment of 1:4 into the majority judgment of 3:2. In my view, such a pronouncement has come to be as the most pleasant surprise, as we heard in the 7 issues reference a resonance of my own critique. What were the 7 issues reference? These were the, I would not like to bother you. These were the 7 issues they framed by a majority of 3:2. They said, no, this issue need to be referred to the 7-judge bench. 2 other judges, they said, nahi sab, they said by majority. Now, I studied these 7 issues carefully and tried to find out what the centrality of the 7 issues that require deeper consideration by a 7-judge bench of the Supreme Court. How do we decipher the centrality? How did I do? A bare perusal of the serialized 7 issues, that is from 1 to 7, that issue listed from serial number 2 to 7 are mere exposition of the various facets of the issue at serial number 1, which indeed is the basic fundamental question of constitutional interpretation, namely, how to construe an interplay between the fundamental right to equality and non-discrimination on one hand, and the fundamental right to freedom and religion on the other, on the constitutional scheme of things. So ultimately, this is the central issue of 7 issues. The other, from 6 to 7, serial order, they are merely an exposition of the first issue, and first issue is the central issue. Now, second development took place, and this took place on January 6, 2020. On January 6, 2020, when this 7-judge bench met, the Supreme Court constituted a bench of 9 judges instead of 7, as was envisioned earlier, for hearing the 7-issue reference, which will commence hearing from January 13. So, when they met on January 6, they referred to the 7-judge bench. Okay, this issue is so important, 7 issues are so important, these need, and 7 issue mean one single issue, major issue, correlation, interplay between right to equality and non-discrimination on the one hand, and right to freedom of religion on the other. This issue is so third development, and it took place on January 13. On January 13, at the commencement of the hearing, the 9-judge bench of the Supreme Court clearly clarified that it will confine itself in answering the larger issue and will not decide the review petitions. Again, they come to the focus issue. Now, in the light of this backdrop, now I say, what is the functional value of my critique, which I presented on August 27th? Our critique on Saprivara Temple case, 2018, carries a distinctive critical functional value, inasmuch as in it, we have not only anticipated the centrality of the 7-issue reference by specifically raising 3 critical issues for exploring the interplay between the right to equality and non-discrimination under Article 14 and 15, but have also responded them in full measure. Since these very questions are yet to be answered principally by the 9-judge bench in response to the 7-issue reference, their response is keenly awaited, as that would enable us another opportunity of revisiting the critique and to see for ourselves in retrospect, once again, how far we are justified in comprehending the constitutional jurisprudence and say with a certain degree of certainty that in the realm of freedom of religion, read with the right to equality, freedom of religion should not be mistaken for freedom from religion. And in fact, as I said, the foreword to this critique was written. The matter was pending for the judgment. Justice Ashokban sent a copy of this critique, published form, to each one of the justices on the 9-judge bench, and also to the senior lawyers who were arguing on both sides, a copy to each one of them also. Is it to be fair? So I was on trial completely. Then the final for today's presentation, my 3 submissions. My first submission is the attainment of pluralist social order, indubitable, opens a new vistas for inclusive society, which has emerged as a universal principle of peace and development. For inclusivity promotes unity in diversity and strengthens democratic participation without undermining or compromising the dignity of the individual. And this indeed is one of the cherished constitutional goals. My second submission, the notion of access to justice is merely a means to reach the goal of pluralist social order by continually resolving conflict of interest in a just, fair, and equitable manner as mandated under the Constitution. And my third and last, for attaining the goal of pluralist social order and making it lasting and sustainable, we need to draw inspiration from the Indian classical tradition, which prompts us to transform rights-based conception of rule of law into dharma-based jurisprudence, because the latter, that is the dharma-based jurisprudence, it generates the requisite propelling force from within rather than from without, and thereby obviating the need of having access to justice as a separate entity, as it envisaged under Article 37 with respect to the directive principles of state policy. And I must say, thank you.
Sir, on that note, I would request all the participants before we move to the question answer session to pay a standing ovation to Sir for his lecture today. Okay, so Mrityunjay, I hand over the dais to you for moderating the question answer session.
Thank you so much, sir, for such a wonderful lecture on legal pluralism and legal pluralistic society. Now, I would like to invite questions from the participants. Okay, Neha.
can start with Neha, then Pushpanjali ma'am, then.
Good morning, sir. Thank you so much for an enlightening critique on the decision. Though I also fall into the category of the modernist in the initial breakdown that you've made. However, you've made excellent points and you've made me tilt towards the idea that the idea of modernist itself is a facade. In that line, I have a question, sir. So my question is it the place of the court to undertake social reform? And how does this understanding stand justified at the cost of reaching a constitutional decision which are not incompatible with the constitution? In short, sir, my question is, the courts are taking up this idea of social reform, but it comes at a cost that you're coming up with judicial decisions which are not in compatibility with the spirit of the constitution. How do we justify this? And is this not denying access of justice then to those petitioners in that case?
Okay, Pushpanjali ma'am, you may also. What is your?
I may respond one by one because I've
Oh,
used it thread and I would not be able to satisfy the question because if I do a kind of a,
Okay, thank you.
I think if I understand, first thing that I must qualify my statement by saying whenever making a twofold classification of modernist and traditional, I said this is just only to make a kind of a distinction. It was not, I'm not in any case denying the value of being modernist. So I am. So it was only from that, just only making a point of distinction. कि क्या उसको कैसे distinct करेंगे? Another thing which you try to bring out here is it the role of the Supreme Court to bring reforms religious? You have answered yourself that directly it is not, but it is only indirectly when an issue comes before the court in the form of a conflict. Now, what is the form of a conflict? It was always involve the conciliation or reconciliation of the competing interests. Now, in the competing interest, it is natural in a pluralist society. So much so, a pluralistic social order, if you extend, each one of us is a distinct identity. Each one of us. Each one of us. And sometimes I wonder of the thumb impression that how in this small space, infinite number of variations can be there. No two thumb impression could be the same. They could similar, not could be the same. And when this is the physical manifestation of individuality. When you come to the thoughts, it is still final. So therefore, and what is the basic purpose of fundamental right? Basic purpose of fundamental right is to maintain that individuality as far as possible. As far as possible. So I think as a teacher, you must have also encountered in teaching Article 14. कैसे पढ़ाएं right to equality? कैसे पढ़ाएं? So right to equality is a kind of a concept, a contrived concept by the social scientist to make it functional society. So it's a broad kind of a classification. And it is not a basic that this is the only way, it changes its view. So it's a very complex process. Complex process in the sense that each one of us is an individual. In the course of justice, what happens is that if there are 5 petitioners or 5 defendants, each one of them have their own lawyer. So the issue is the same. Why? It is the replica of the same idea. Who knows that he may have something special which may not be between the others. So therefore, each one of us has.
Yes, Pushpanjali.
I've not completed the answer. Have I answered your question?
I would like to reiterate the question, sir, very briefly. My question was, we talked about how this understanding leads to access to justice. In totality, we were trying to understand the role of how.
To that, my answer is that I said access to justice is an indispensable element of pluralist society. What more do you want me to say? It is an indispensable element to the pluralist social order.
My question was, in coming to conclusion on larger issues,
Yes.
is the court not violating the rights of the petitioners in that case?
Okay, clear. Can you clarify if you understand?
Do you say that petitioners have their right to go court and to protect their fundamental right to religion? So in this case, Supreme Court violated their rights. This is what you were saying.
The court, instead of just looking into issues,
See, I think, when I have to frame question, do you have to take this except multiple number of times? I keep on writing, is that, have I said what I wanted to say? Have I communicated? So therefore, you have to be very crystal clear. You have to write your question specifically in a statement. Then only you will be able to, in the meanwhile, do it and come.
Yes.
Good morning, sir. Myself, Dr. Pushpanjali. So I want to ask one question. When we talk about UCC, Uniform Civil Code, which is given in directive principle, so while achieving that, will it not hamper or it will not be against this legal pluralistic society which we talked today?
I think you have raised a very critical question, you see, because it was conceived in a constitution, Uniform Civil Code, and we have not succeeded till now. Now, my own understanding is that right in early 50s, this was the first area of codification started. First area of codification was the Hindu codes, which you see. And it started right immediately after independence, after the coming into force of this constitution. And in a hasty process, you could see that Hindu Marriage Act of 1955, Hindu Succession Act of 1956, Hindu Minority Guardianship Act of 1956, Hindu Adoptions and Maintenance Act of 1956. All these acts were passed within a span of 2 years. And it carries the name of Hindu Marriage Act. My only hunch is that if the word Hindu would not have been used right in issue, it would have been used something common, neutral, Indian Marriage Act. Probably this kind of a situation in which we are caught, we would not have been caught. But nevertheless, if I could see the work which they have done of unifying, the only thing is that in the first instance, let us unify all the major communities, and all the major communities keeping into the background of the British colonial rule, in which they have got the different personal laws. They said, who is a Hindu? First, there is a kind of positive definition, who is a Hindu, Dharma Samaji, Arya Samaji, and so on and so forth. Or a negative definition, a person is a Hindu who is neither a Muslim, Christian, Parsi, or a Jew, is a Hindu. Now, this is the kind of a scenario. Now, question is that if you look at the Section 7 of the Hindu Marriage Act, solemnization of marriage. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either. So, in this very concept, they have introduced a lot of flexibility. That where Saptapadi, since it was a common kind of a thing, where Saptapadi is the requisite ceremony, when 7th step is taken, marriage. Or customary rites and ceremonies. No, customary right varies from one community to community, one state to another, and so on and so forth. So it was, he said, if you perform those, they were perfectly valid. So they unified to a lot extent by introducing this very notion. Now the next thing is that there has to be one code. What name would you give that code? First, the government has to decide. What name would you like to give that code? And then under the rubric of that code, when you come to the grounds, you said, what have we done so far? We have codified, we have introduced divorce. This is the first major change which has been brought by the Hindu code. That earlier Hindu marriage was a sacrament, it was indissoluble. Not only indissoluble, it was eternal. Not only in this life, in all lives to come. But this act of 1955 cut down that. Instead of that, what did he do? He said, no. Divorce is possible because Hindu marriage is a, two parties are agreeing into get into marriage as a partner. So they should be free, logically. So does it mean that the Hindu Marriage Act promotes divorce in society? The answer is no. Now then we say, on one hand you introduce divorce, on the other hand, Section 23. Section 23 says, clause 2. I taught a long time in the Marriage Act, but now maybe 40 a little bit, but basic principles are clear to me. That in every petition, whether defended or not, it was the first and foremost duty of the court to reconcile the whether defended or not, irrespective of it, which means court itself becomes a party. It's not merely a question of A versus B. A versus B, court is a neutral. But if the court itself, whether defended or not, what's the meaning of this, whether defended or not? The court itself has to exercise the role of a lawyer, which would have been represented by the other party. So it's a kind of a, which means ultimately, look at the English law. We are following the English law, but we have not understood the basic principle. English law, I think way back in 1967, they abolished all grounds for the dissolution of marriage and kept only one ground, and that is indissolubility of marriage. Only one ground. And now we are saying time and time again in parliament, outside parliament, in judgment of the Supreme Court, that indissolubility of marriage must be made an additional grounds. What mean additional ground? Indissolubility of marriage is a concept which subsumes all grounds. And we have not been able to understand between just a final distinction. And we are saying uniform civil code. What kind of a uniform? When you come to the grounds of marriage, cruelty, desertion, adultery, and this desertion, cruelty, adultery been defined in this statute? The answer is no, it is undefinable. So therefore, it would vary from what is the uniform civil code? So therefore, my hunch is that this uniform civil code, it has to evolve itself. You can't force from outside. It can't force from outside. And if you want to legislate, codify, then you have to prepare a kind of a wide debate, discussion, taking up all the clues on this time. Where is that discussion? Chief Justice Ramanna has said that any legislation passed by the government, by the state, where is the discussion? He lamented. And that's true. And without it, what happens is we pass and haphazard, half cooked. And this creates a catastrophe. So therefore, your raising a question is important because uniform means something is to be done on part of the state. But why the state has not been able to do so? That's the question. Yesterday, I gave you an example. State of Haryana has created 40,000 scholarships, you see, and the takers are not more than 2,000 rupees. Or state can gleefully, look here, what chivalrous decision we have taken. We have made facilities. So they forget Article 45. They forget the implication laid down in Article 37. So ये जो complexities हैं, ये हमें लानी है. And I think I can't miss to quote Professor Abhijit Pathak, to whom I quoted yesterday. He said that criticism करना हम भूल गए, criticism, critic, raising a question. And that is missing in all this private coaching center. This is conspicuous by its absence. And multi-objective type of question, yes, no, further taken me a proceed to critical examine. Why? I encountered a problem while conducting the judicial examination for the state of Punjab, Haryana, and Chandigarh. Question कैसे manufacture करें? How to overcome the predicament which is caused by these institutions, you see. Because coining of a question multiple form, it needs a lot of exercise. And then social sciences, they are open to multiple interpretations. It will challenge the court of law के सब mechanical answer चाहिए. तो उसका नतीजा क्या होता है? Majority of the questions are factual. कि साहब इसकी राजधानी क्या है? वो कौन सी डेट को बॉर्न हुआ था? इसका टाइटल क्या है? Where is the capacity of questioning? So I think this is the you raise the question, think about it.
Yes.
Thank you so much, sir. And like first day, second day was equally a delight to. Sir, when you were, I mean, I kind of do an analogy because when I look at the judgment of Muralidharan T versus State of Kerala, the question was asked pertaining to ban on animal sacrifice in the presence of the temple. The act says that you can sacrifice animals and birds for your own consumption, but not to appropriate it to the deity. So this was Kerala High Court's judgment. When it went to Supreme Court, and three-judge bench, Justice Bopanna says, and he noted, when he just said the look of it and glance, he noted one thing. He said, I'm surprised that they're happy with the fact that you kill animals for your own consumption, absolutely, but you cannot appropriate it to the deity. Question is that are we banning animal sacrifice on the ground that it causes cruelty to animals? Because if the state proceed in that line, then it should ban that in all religion equally. So I think it's not only the Supreme Court which is caught in the dichotomy, I think it's the Parliament also trying to regulate only one, single-minded blinkers that I have to ensure that the majority adheres. Minority, I'll take care. So that is what Justice Bopanna says, that if you're talking of banning of, animal sacrifice in the temple sense, then you should think that you're banning because it causes cruelty or why. And still that judgment is pending. We are awaiting the result. But in most of the, because I'm a follower of Shakti, and in the temple in Bhadrakali, where I visit our maternal site temple, we offer which is called bakra to the goddess. And the animal sacrifice still takes place, and they believe it to be part of their customary practices. My question, I could understand if my learned young friend here would agree with me. What I had a similar line question, sir. She's asking that if I am a person who's practicing any religious, correct me if I'm not, if I am the person practicing any, religion, and we have been doing it from time immemorial. And when it comes to the court of law has not in all cases, but in some cases has been very insensitive to control such practices in the name of this very strong right, which is right of equality, which I think was quite appreciated by Justice Indu Malhotra in the dissenting Mukti. This is what I have to say. That even Parliament is caught in that dichotomy. It's not only the Supreme Court.
I would entirely agreeing with you, but I would just only extend that not only the Supreme Court, you said that Parliament should also be, I would further enlighten it. Not only Parliament, but it should include you and me also. So therefore, it is this kind of a conglomeration, if it is organized, and how would we be able to make them convergent? Only in cases of discussion and dialogue. Now, this discussion dialogue must go on, you see, must go on. And then you would see that it percolated to the various facets of life. Then you would go to the scheme of nature. I remember a quote from Nehru, very simple thing he said. He said, animals kill, but they would kill only to satisfy that need, not beyond that. Why the men kill? They kill indiscriminately. So it's just a kind of a proposition he changed. He also said that I don't need that we need more than a bicycle, you see. Rest is you can. Now, if you apply this kind of a situation, we have got cars in terms of speed, this many horsepower, this many horsepower. Then you have to see that for what purpose do you see? While coming from Chandigarh to Shimla, we saw a motorbike. And I asked my friend that what is this kind of a he said this would be something like 30 or 40 lakh rupees motorbike. He said, what is it? He said, it picks up a speed of such a speed. I said, what do you do with that speed? No. So therefore, it is we who have to decide. This is the most important. And then ultimately, if we are able to develop that kind of an individualism, that I as an individual, because I am an individual, my individuality has to be protected. So if my individuality is to be protected, I should be able to amplify, crystallize what that my thinking is. And that would generate a kind of a debate. So I think you are right. Become a participant of the debating society and hope so. I am not lost all hope. And particularly when I come to participate and interact with young people, I still feel happy that no, my young people are still interested. Otherwise, how can I hold them for 2 hours? I just can't hold them for 2 hours. It's only the your response has made me responsible. Your response has made me responsible. Thank you.
Thank you for a wonderful session. So my question is, customs like sati pratha and child marriage were enrooted in society for a long time. If we would have given the priority to freedom of religious customary practices, then these social reforms, banning them, would not have happened. So how far do you think judicial pronouncements are the tool for the social transformations?
See, to that my response is that any practice which comes into, which means customary practice. And what is a customary practice? How does it evolve? Can you trace the origin of a custom? To that we would say that it is there for since time immemorial, because it is the memory we don't know. And what is the beauty of a custom? If I have to demonstrate custom on a graph in comparison to a statutory provision, if I have to demonstrate on a graph, a statutory provision representation would be a straight line. Whereas custom, it would be a zigzag route. Now, what's the difference between the two? The difference between the two is that in case of a custom, the society is who made the custom? Society. Which is society changing every point of time. And if you want to know a direction at a point, mathematically, you draw a tangent at that point only, then that would determine it. And as we said that this earth is round, you see, but we see flat. How do we see flat? Doesn't mean that if we see flat that it ceases to be round. That is, curvature is so big that any 2 points in proximity would almost, though there is a curve, but that curve is invisible. So, which I am trying to say here is that the beauty of a custom is that it spontaneously changes according to the changing needs of society. It's going to change. And so therefore, it is not It is not a customary force from outside. Even the great reformers who have been there in the past, who reformed this society, who reformed these practices, how could they reform these practices? They could reform only by going in amongst the people, creating an awareness among the people, so that they can themselves can unfold. I think that is the only best way of changing it. So therefore, you may conceive an idea which there's a wide gap. But then for the social scientists, for the lawmakers, is to see that how you can change, how you can bridge that gap without causing a crisis, without causing a void. See, this question arose at the time of framing of our constitution. In retrospect, people say that no, we should not have framed our constitution on the basis of the colonial past. We should have framed. See, look at the scenario at that point of time. Partition. It's the biggest movement of the human population in one go. In the human history, in one go. At that time, who would do it? How would you do it? So therefore, the point which I'm trying to say is that you can philosophically, realistically, you can move only from a place where you are, not from a place where you are not. So जो दूरदृष्टा होते हैं, they have envisioned, but then how to, and that's the beauty of, if I take the Indian classical tradition, in the classical tradition, there was an absolutely desirable norms, and then there are customary practices. Now the Shastrakars mean those who are responsible for laying down the law for this society, they faithfully reproduce the customary practices and also the norms which are to be achieved. You see, for example, we have got the 12 types of marriages. You know, Gandharvata, Rakshasa marriage, Pishasha marriage. And then we said, then these are approved, these are not approved. And then how we move from one to another, it's a very gradual progression. So what they indicated, because Shastrakars were aware, they were great lawmakers. They were aware that if you want to improve the society, you can take them from where they are and then you move them upwards. But if you do that with a jerk, it will be acceptable. I take the analogy. My wife is a medical doctor. She gave me this. He said, blood is life, you see. And then how do you give the blood, you see? He said, drop by drop. His life will be bottle, what would happen? So she told me, he said, medical science also follows the same philosophy.
So I think that every constitutional interpretation brings change. That change is a progressive change or regressive change. How this particular dichotomy is established, whether there is mentality that whatever happened in West is rational for the rest, and on that basis, are we creating a dichotomy between progressive?
I think I would not call it a dichotomy because any change which is reflected, we said it can be deciphered in two ways, either retrospective or whether it takes up or whether it takes down. Whether it takes up or takes down, what will be the determining factor? I think determining factors are no other but the people themselves. If it is acceptable, we move. If it is not acceptable, you make a change. But you cannot adopt the attitude of no nonsense by calling that my view is fine, and so therefore, which is not acceptable. And that is the value of the democratic process. Democratic process is a slow one, but it's reasonably a sure one. We have seen all the world over, gradually all the societies are moving towards a constitutional order or a democratic kind of a setup. Though it's a different matter that the big power, they think that they are responsible for ushering in, which is rejected, which is nothing doing, because all kind of a reform has to come from within, not from without. And in case of religion, we have seen that even in 21st century, you raised an objection against Prophet Muhammad, it becomes an international issue. Supreme Court is caught. सब एक छोटे से word ने आग लगा दी. Now the question of whether the Supreme Court judge himself should have said it, or my own opinion, because the student did ask me, आप ये क्या ख्याल करते हैं? मोबाइल पर आते मैसेज. What do you think of this statement of? I said, in the first instance, when the judge said, he was reflecting what he's seeing in this way. He's a part of the society. So there is nothing wrong. It was a kind of a spontaneous reaction. And there's a difference between a spontaneous reaction and writing a judgment. Writing a judgment and spontaneous reactions are different. Because I have found in my critiquing that I have taken a stand, but later on my own examination, I find that no, you are shaking. I change it. So therefore, it is the people themselves. It is the people themselves who would be the determinant of whether it is retrospective or it's progressive. Sometimes retrieving a step is progressive. Sometimes retrieving a step is progressive. You see. In family setup, I have seen, I remember quite a few years back, it was from a creator, a person, well grown up. I think he must be around 45, 50. He fell in love with a young girl, hardly 20. And they decided to get married. And then their parents came in between. They were very unhappy. He said they would never let it happen. He said, my advice at this juncture was, he said, no, you try to appreciate the sentiments of the young girl. She who is a grown up, she is not a minor. And to say that all right, we would do it in a proper manner and so on and so forth. So they retrieved their earlier situation, took on, and then they tried to bring the various perspectives. They're saying all the time, we will do as you like. That's fine. But our apprehension is, number one, do you see the kind of a age difference? Do you see the kind of a situation? Do you see his career? Do you see a number of things? I tell you that reversing became a progressive step. So therefore, this kind of decision making is important. See. My wife gives an example for the medical profession. The first thing which you do is, if a patient comes to her, all medicine is what is the ailment, it is not clear, taking the, he said, stop all medicine. He said the patient would die. He said, we will see. So retrogressive step in the sense, though that you are eliminating all, because until unless you are able to diagnose it properly, nothing is. So therefore, this is a relative.
Can I ask?
Yeah, please.
Interpretation of the constitutional morality, that reflection of the personal morality of the judge.
I said so clearly by interpreting it that morality public order and health. And here the term morality is to be construed from the point of view of the devotees rather than of the courtiers. Because that is the essence, freedom of conscience. I have argued with myself a number of times to see, because we are, we don't go to any temple, church, gurdwara or anything. My wife says my patients are my temple. I feel my own students are my temple, you see. But at the same time, you see millions of people come on a ghat and on a particular day, I don't know from where they come. But the question is that, should I close my eye to this reality that they do come, they do sacrifices, they do animal sacrifices, they do even human sacrifices under a kind of video. See how, but this is the reality which happens. Then I have to further find out how this happens. Sometimes we may answer, sometimes we will answer. In discovering the human universe, what did physical scientists do? Physical scientists do say, how does it happen? He cannot answer why does it happen. He can explain only how does it happen. He can't explain why does it happen. It's a limitation. So similarly, social scientists have got their own limitations which are raised in various questions, but then we try to resolve through discussion and dialogue. Yes, your question was, sir.
No, I don't have a question.
Okay.
So I think if there are no questions, then yeah, go ahead. Go ahead.
Because sir,
Fine.
not that I'm asking you questions.
No.
I am.
Why do you feel shy?
Since you've persuaded me in reframing my question, I think I have organized my thoughts.
Okay.
And if I could put it very briefly, in its zeal of being a social reformer, is the Supreme Court abdicating its constitutional right of protecting the fundamental rights. In its zeal of being a social reformer, is the Supreme Court abdicating its constitutional duty of being the protector of fundamental rights, sir? That is my question.
No, why is that? Why are you saying that they're abdicating the responsibility of protecting the fundamental right?
Because sometimes,
No. I said that it is the fundamental duty of the Supreme Court to protect the fundamental rights. It's the fundamental duty of now, how did this process of protecting fundamental right comes in? It's the adjustment of competing interests. And then how the competing interests are to be harmonized. Now, here, they can be wrong or they can be right. But for the test of being right, we go to the founding fathers of the Constitution, what they have drafted. As I have told, I have not said that the Supreme Court should abdicate the responsibility or have abdicated the responsibility. No, this is the primary responsibility. Rather, I would enlarge on this in, because I have done a critique on Ayodhya Babri Masjid case, which I found it very, very interesting and intriguing, in which the Supreme Court has said that it is the duty of the Supreme Court to protect the Constitution. Not only the fundamental rights, but the whole Constitution. And ultimately, they said if you come to the competing interests, you come to the fundamental rights. And in fact, the whole concept of basic structure doctrine that has come focused on the fundamental rights. So, उस competing interest पे evaluation में, they may be right, they may be wrong. As for example, in my case, I found out in Ayodhya Babri Masjid case, I found the other way around. I found that this was one of the best judgment they have done. Whereas I have come across a lot of criticism against the judgment, and I have tried to meet that criticism in my presentation. So therefore, the basic premise, you are very right that their basic premise is to protect the fundamental right. It is a bounden duty. But in the process of protecting, there come the various caveats. And those cases are nothing but the adjustment of rights. Adjustment right में गलत भी हो सकते हैं. जब एक डॉक्टर डायग्नोज करता है, डायग्नोज गलत भी हो सकता है, ठीक भी हो सकता है. But the only thing is that your diagnosis, so long, ठीक diagnosis किसको कहते हैं उसको? A diagnosis which is informed. Informed by what? Informed by experience, informed by existing literature, informed by existing practices. तो ये है, until you are able to say कि ये existing practice ये गलत है, इसको modify कर रही है. So this thing.
Thank you, sir. Yes, sir.
Okay, so on that note, दो लाइनें सर याद आती है. रामधारी सिंह दिनकर ने लिखा है, कर्ण के लिए लिखा था, but listening to your story of life along with the lectures and the kind of work that you have dedicated, वो लिखते हैं कि शूरमा नहीं विचलित होते, क्षण एक नहीं धीरज खोते, विघ्नों को गले लगाते हैं, कांटों में राह बनाते हैं. And second, it is always said that there is behind every successful man there is a woman. I would just change the tone a bit in the modernist tradition, and I would say behind every successful person there is another person. And once again, we thank Max for being here with us. We also thank you, sir, for both these sessions. And we are humbled and privileged by your presence, sir. Thank you so much. Thank you so much.
Thank you very much. I just sincerely humble. He says we have done that. Yes.